Yes. Here we are. Okay. So thank you so much. I will just leave immediately the floor. Sorry.
Okay. Dear colleagues and friends, good afternoon. It's a pleasure for me to open today's seminar on law and pop culture in China, the three-body problem by Liu Cixin. I would like to warmly welcome all participants here in Pisa, as well as those joining us online. At the first glance, the three-body problem may seem an unusual choice for legal discussion. It is, after all, a science fiction novel dealing with alien civilizations, cosmic physics, and the future of humanity. And yet, this is precisely what makes it such a fascinating topic of study from a law and literature perspective. Since its publication, Liu Cixin's trilogy has become a global culture phenomenon. It has contributed decisively to the international visibility of Chinese science fiction, and through its recent television adaptations has entered global popular culture. This success invites us to ask not only literacy or cultural questions, but also legal ones. What kind of world is imagined in these books, and what role do law, institutions, and rights play in moments of existential crisis? So the trilogy offers a surprisingly rich legal imagination. International organizations, particularly the United Nations, are portrayed as central actors capable of mobilizing resources, shaping collective values, and responding to global threats. And at the same time, the books raise complex questions about the relationship between security and freedom, technology and human rights, public authority and private powers. So themes such as surveillance, control, and the limits of free will resonate strongly with contemporary legal debates, far beyond the fictional context of the story. For these reasons, today's seminar brings together scholars from different backgrounds and legal traditions to explore how popular culture can help us reflect on law in new and sometimes unexpected ways. I would like to sincerely thank Professor Lorenzo Gaspari and Professor Giuseppe Martinico for conceiving this initiative, and all the speakers for their willingness to contribute, for your willingness to contribute to this interdisciplinary dialogue. Unfortunately, Professor Giuseppe Martinico was unable to join us in person today due to a family medical reason. So we send him and his family our best wishes. I'm confident that today's discussion will be both intellectually stimulating and enjoyable, and that will show how law can engage productively with literature and pop culture to better understand the challenges of our time. Thank you very much, and I wish you all a very fruitful seminar. I would like to give the floor to Lorenzo.
Yeah, thank you so much. Thank you so much. That's been nice introduction. Well, I will not spend much time, but just leave the floor to Professor Li. If you would like to share your screen.
Okay, so I will share my PPT slides, right?
Yes, perfect.
Okay, okay. Okay, so can you see the slides?
So we can, perfect, thank you.
Okay, So, okay. So I'll show it.
You can start when you want.
Okay. So now I can begin my presentation, right?
Yes, please.
Okay. So buongiorno, and it's a privilege to be here. So today I'm here together just with my colleague and friend, Professor Chen Qi, who is from the School of Law, Yat-sen University. But because he has some important work, so he might just appear just later. At this moment, I will just present his research just on behalf of him. And we will here approach Liu Cixin's The Three-Body Problem, not as a sci-fi epic, but as a rigorous thought experiment in legal philosophy. As this paper argues, the trilogy posits a fundamental challenge for future jurisprudence. When an existential crisis causes the old world to collapse, what kind of new human and new law are required to construct a new civilization capable of survival? This presentation will follow the narrative's progression, deducing three distinct paths for civilizational salvation through three core characters: Luoji, the sword holder; Chengxin, the saint; and Zhang Beihai, the legislator. We will explore how their fateful choices test the limits of our legal and moral imagination. So here, my methodology treats this novel as a model for a possible world. On the right of this slide, this is a book about the co-edited by Professor Chen Qi and me, just about including the research papers and articles and comments just upon the three-body problem after it was published in China. And the methodology I will use today allows us to conduct a thought experiment. We will test three hypotheses for civilizational survival. Experiment 1. Can a deterrence constitution based on a solitary sovereign work? This is the path of Luoji. Experiment 2. Is the old law based on universal human love effective in a cosmic war? This is the path of Chongqing. Experiment 3. If the first two fail, is the new space for legislators the only viable option? This is the path of Zhang Beihai. Through the three cascading tests, we can analyze the deep connections between human nature, legal order, and civilizational destiny. Our experiment begins with the collapse of the old world. This collapse happens on three fronts. First, and most fundamentally, the foundation of human nature is falsified. The old world operates on two core presuppositions. First, the human civilization can self-perfect through its own internal moral strength. And second, that the flourishing of technology is necessarily accompanied by moral improvement. But in this novel, Ye Wenjie's personal epic serves as a thorough falsification of these two beliefs. Her choice to contact the aliens, born from her profound despair over humanity's inability to overcome its internal conflicts, demonstrates that within the thought experiment, our species cannot rely on its own morality to self-purify. Second, the old law fails. The legal system designed to protect the individual rights proved incapable of stopping the Earth Twicellaris organization, that is the ETO. As a character Zhiqiang cynically notes, the enemies operate legally, while the government must break the law stops them. This dissolution of the rule of law pushes society into a state of exception, setting the stage for a new form of power. The final pillar to fall is rationality. The softened blockade holds fundamental scientific progress. The Enlightenment belief that science can solve everything is shattered. Summed up by the desperate cry, physics does not exist. This collapse reveals the true state of the universe, the dark forest, or Hobbesian state of nature, where every civilization is a hunter. With the foundations of modern civilization, humanity, law, and science all falsified, a vacuum is created. This vacuum demands a new kind of individual, a new human, to rise from the ashes. And this brings us to Luoqi. So Luoqi's story is a microcosm of humanity's painful evolution. It has three distinct phases. First is an egotist, a cynical product of the old world, utterly indifferent to collective fate. Second, he becomes the war-facer, a role forced upon him. Even then, his initial motivation is selfish. He uses his immense power to find his imaginary lover. This act, however, paradoxically becomes the catalyst for his transformation. Finally, he becomes the sword holder, a lonely sovereign who accepts the burden of becoming the greatest criminal in the history of two worlds. This story is the answer to the question, how can an egotist become a hero? It is a journey from selfish desire to existential responsibility. Initially, Luoqi is a perfect Hobbesian man, driven by desire and the pursuit of personal praise. However, a thought experiment introduced the two catalysts that push him beyond this state. First, love. His relationship with Xueyan transforms his abstract desires into a concrete responsibility for his family. He now has something to lose. Second, threat. The catastrophic failure of the human fleet in the Battle of Homestay awakens his will to fight. He is forced to confront a choice: either remain a selfish individual and watch his loved ones perish, or embrace the master morality and fight for recognition. This crucible forges a new human from the clay of the old world. As a sword holder, Luoqi becomes the sovereign of exception. His power is unique. It is solitary, resting on one man's will, irrational, based on the threat of mutual destruction, and existential, prioritizing survival above all morality. This establishes a deterrence constitution that suspends the normal civilization constitution. However, this creates a profound paradox, which is the core of Luoqi's tragedy. The very people he protects, the old humans living in peace, begin to use their old morality to condemn him. They see him as a tyrant. The new law that saves them is rejected by the very society it preserves. This internal contradiction is unresolved. The peace brought by deterrence does not strengthen humanity. It weakens it. It creates what Nietzsche called the society of the last man. This society is obsessed with safety and comfort. It forgets the reality of the dark forest. Men become feminized, and society develops an extreme intolerance for anything perceived as cruel. The political consequence is inevitable. They reject the terrible father figure of Luoqi. They demand a new sword holder who is a mother. Someone represents love, not terror. They want to be told that the universe is a safe and loving place, even if it is a lie. This demand is met by Chengxin. He is the perfect symbol of this society's ideals: motherly love, human rights, and universal values. Humanity elects her precisely because she is safe. They know she will never press a button. Her failure is therefore not a personal one, but a failure of the last among society itself. When the moment of truth comes, she acts exactly as they wished. She upholds the ideals of the civilization constitution, choosing not to harm another world at the direct cost of her own civilization's survival. This experiment proves that the old law, when combined with the last man and in the absence of the new human, leads to ruin. Rousseau's legislator, an extraordinary figure who designs laws but does not rule. The failures of both Luo and Cixin points to a fundamental dilemma. The old soil of Earth is infertile. It cannot produce the new humans needed for survival. Even Luo could not act as a guardian. He could not transform the people. This leads to a third and final path, Exodus. Here, we introduce the concept of the Rousseau's legislator. This is not a king or sovereign, but an extraordinary founder who designs the laws and shapes the spirit of new people, but does not ruin them. If Luo was a sovereign who protected, who could be the legislator that builds? And here we have the answer, Zhang Beihai. He is a revolutionary who understands that humanity on Earth is doomed. He hides his strategic defeatism behind a mask of firm belief. He takes two decisive actions. First, he assassinates conservative scientists to force humanity onto the path of Xueyan for power. Second, he hijacks the starship of natural selection, creating the first breakaway civilization. He is not merely escaping. He is a legislator creating a new isolated space, a legal laboratory where a new society can be built from scratch, free from the moral baggage of the earth. In this new space, Starship Earth faces a constitutional dilemma. Should they choose a totalitarian regime for survival or democracy to protect personal rights? Zhang Beihai shows his wisdom as a legislator. He rejects this false dichotomy, arguing that both are traps from Earth's failed history. He proposes the Starship Constitution, an organic synthesis. First, it established survival as an absolute collective principle. But second, it recognizes that development driven by individual liberty and creativity is the best guarantee for survival. This is not Luo's pure discipline, nor Chenxin's pure humanity. It is a new dialectical solution. Zhang Beihai's greatest act as a legislator is his selflessness. When the people elect him as their absolute leader, he refuses power. He understands that a true legislator sets rules but does not rule. He must force the people to grow up and become a sovereign themselves. He dies in the battle of darkness, the brutal rite of passage he knew as necessary. His last words, "Don't worry, it's all the same," signify his ultimate trust in the new law he created. It doesn't matter who survives, because the survivors will be new humans forged by the new reality. His ego is transcended. The law lives on. In conclusion, our thought experiment reveals three paths. Luo's path led to an internal contradiction, a new law protecting a decaying old society. Chengxin's path was a complete failure. The old law led to extinction. Only Zhang Beihai's path was a success. He created a new space where the new law would cultivate new humans, leading to a new civilization. The solution lies in a dialectical unity, acknowledging survival as the primary need, while striking a different balance between collective discipline and developmental freedom. And finally, what does this mean for us as legal scholars? The novel ends with a warning. Weakness and ignorance are not barriers for survival, but arrogance is. The greatest legal arrogance is assuming that Earth's laws are universal. And our challenge is to transcend the simplistic dualism of survival versus morality. We need to design legal systems with resilience and adaptability. Like Sant'Anna, our task is not just to interpret the laws of the past, but to become legislators of the future, to have the courage to imagine new laws for a new world. That's all. Thank you.
Thank you so much, Professor Lee. Very interesting, wonderful. Looking forward also for the discussion later. Professor Ruotolo, would you like to take the floor?
Here we are. Thank you a lot for the invitation. It's a pleasure to be here. And so, as we used to say, in medias res, beginning from the center of things. No, to me, as a European, seems that China's pop culture and law share a complex, symbiotic relationship that is shaped China's objectives as a state, but not only, also by its societal values and objectives. And this is the framework in which I try to speak of what I'm going to speak. Chinese law regulates content as every state and domestic law and covers news, movies, music, TV, literature, gaming, series, and so on. To uphold social stability, it happens in every state, and to reach ideological alignment. And China's state also relies on celebrity culture for little reasons, messaging mechanisms, and also a market-facing force that is used for both governance of celebrities and governance through celebrities. Chinese popular media reflect justice themes rooted in folklore that is very different from Western one, of course, moral codes, judicial tradition, and as in West, pop culture serves as a formative space and also as a way to normalize debate and even subtly contest legal ideas. And we know that the three-body problem is built on this approach. In this context, I also need, I think it's fair enough to speak a little about the approach I should say we, because this is a work I'm going on doing with a colleague of mine, Giuseppe Martinica, that is also a great friend of mine, it is not here today. Our approach about the relationship between law and pop culture, I think it's important for you to understand. The way a phenomenon, every phenomenon, from technology to family life to sexuality to politics and so on, is represented in pop culture corresponds to the perception held by the majority of people. This is how that phenomenon enters and lays its root in our collective imagination. Popular culture is nothing more than the set of traditions, knowledge, ideas, customs that constitute the dominant trend in a given context. And it acts as Asimov said, not Asimov, but Asimov said as simultaneously as a mirror and as a lamp. That is to say, it reflects as a mirror what the community thinks and at the same time illuminates it, making it more visible. But while it illuminates, it modifies its shapes, its forms. And law, with all its facets, I think it's no exception to this. The way in which rules and law protectioners also, university professors and, I don't know, law students and judges and so on, are told and filtered by pop culture coincides with the perception held by specialists. And we strongly think that experts should be aware of this. I'm approaching this in an international law and international lawyer perspective, and as we all know, international lawyers have told us, for instance, Marty Koskiniemi told us that international law is a narration. It's a way to tell people things for some objectives to be reached. No? So we also think that we can use pop imagery to do things, not only to understand, but also to teach. But no, I'm not using now this in this way, of course. And I think also that science fiction has some features that has some peculiarities, no? That take science fiction a step further other expression of culture. Now, for at least 15 years, I've been dealing, among other things, with the relationship between international law and new technologies. So this is another point of view I have. And this, I think, is a point of view, if not privileged, at least peculiar, particular. Science fiction represents, in this sense, just a context for imagining the future of technology and its impact on society. And it's precisely for this reason it proves, to me at least, to be a valuable tool for questioning how law can adapt. International law mostly. And that's why, that's because within a science fiction story, you can introduce rules that react to scientific or technological discoveries in ways that go beyond simple or mere theoretical exercise. Because let's think, when for instance, when a regulator, or a judge in common law systems must develop a new rule, in addition to technical considerations, such as costs and, I don't know, regulatory compatibility with other rules and applicability, comes into play his or her personal experience. And we have to be well aware of this. We, as international lawyers, I think that individual human decisions, emotions, biases, cognitive processes play a pivotal role in creating, interpreting, and applying international law. And I think this challenges somehow the idea that international law is purely rational, and because people, not just states, influence its outcome. We may think to treaty formation or human rights adjudication or this concept, however, highlights how empathy, personal values, human fallibility shape international law. So I think that we have to focus on human actors, but when we switch our attention to emerging technologies, useful personal references are lacking. We have no experience. For instance, let's think, for example, to genetic engineering or space weapons. No, we have no direct experience of this, is absent. So not only we have not experienced these innovations, but we also ignore the effects of different regulatory models on this. And this is where science fiction may become legally relevant, I think. It proposes comprehensive legal hypothesis. It's not limited to rational analysis as an official document of an international organization, but I don't know, as an academic essay, It engages emotion because it's a form of art. And it presents characters who experience consequences of alternative systems and alternative rules. So, as Arthur C. Clarke wrote, by imagining possible and even improbable futures, a science fiction writer performs a fundamental service to the community. And I think that if you look into the case law, for instance, you will find a lot of references to science fiction. I've tried to search, just for today, I find 45 domestic US court decisions that refer to, I don't know, the movie Gattaca, it's about genetic engineering, or George Orwell's 1984. It was cited, I think, in the end of more than 50 years ago. It was the US Supreme Court said something about 1984. It said we had to remind what George Orwell told us in 1924. So now let's switch to the three bodies problem. We don't know what it's about and how it's built, so I'll not annoy you with this. In this, I will try to understand how international law, United Nations and Security Council are told to, and are used by the author. The difference is very, very briefly, because it's very easy. Differences from a real world situation and how science fiction can help international lawyers to try to think possible for some. In the novels, the UN evolves toward planetary governance, something like that, with binding command and coordination powers. In the Dark Forest, there is the creation of the Planetary Defense Council. It is interfaced with the Secretary General. This is institutionalized. Repeat a globally binding decision of resources, fleet, special program, the sole orders, for instance. With a level of enforcement that exceeds state sovereignty, and state sovereignty becomes more and more irrelevant in the novel. The Secretary General is portrayed as the political actor endowed with initiative, operational discretion in crisis management, and the appointment of strategic figures. And in the Yat-sen, this global structure consolidates. There is the pivotal deterrence, the pivotal team axis is the Dark Forest, what I'm speaking about, cosmic threat, no? Conditions, the behavior of civilizations, and already in the three body problem, first of the three novels, there is a parable on Carte Yewenje that introduces the idea that international crisis can legitimate somehow exceptional suspensions of rights and procedures. And so Liu's fiction proposes a verticalized international organization and the constitutionalization of international law with some values that become paramount, something like that. In reality, UN works in a very different way because we know that it finds its basis on the will of member states, on a functional basis. It is true that the Security Council holds primary responsibility for international peace and security, so Article 24 of the Charter, but and it has specific powers, mostly Chapter 7 of the Charter, but in no way it constitutes a general supranational government. Council decision can be binding, we know, but mostly depend. Their enforcement depends on states. There is no UN armed force, and there is the issue of the veto that we will know very well of the permanent members of the Security Council. We all know also that in recent years, General Assembly's so-called veto initiative introduced a post-veto political accountability mechanism without reforming the Charter. And for instance, in 3 years ago, for the first time in history, General Assembly held a debate specifically to address a veto cast by China and Russia at Security Council. But this meeting convened in accordance with the resolution I was speaking about, that is standing a mandate for General Assembly debate when a veto is cast. It is the name. It's A-Res and 76262, if somebody wants to know. But we all know that this nowadays is not working anymore. So proposals such a UN emergency platform, that is another thing, aim for coordinated response protocols to global shocks, but not permanent extraordinary powers, no way. The UN's emergency platform refers to a proposed flexible framework for coordinating responses to major global crises. The difference, so, is not only quantitative but qualitative. In the novel, we see a global executive established. In the real world, we have mandate, veto, states of equity, and ad hoc implementation. So what we can learn from the novels? In the novels, in the current climate regime, for instance, this agreement prioritizes national determined contribution, national climate plans that each single signatory state establishes unilaterally to reduce emissions, and a strengthened transparency framework. I'm thinking about Article 13 of the agreement. But we have no planetary defense council-like thing, but a planetary defense council-like thing that is a coordination of systemic threats could inspire graduated enforcement mechanisms such as automatic triggers and a coordinated response authority to allocate critical capacity. I'm thinking to instruments such as the Paris-aligned exchange traded funds, which invest in companies committed to the climate and low carbon transition. This demonstrates that accountability can be strengthened without creating a global government that seems impossible to reach. But we also know that these things have been, that literature, not only, also practice, highlights limitations in effectiveness of the instrument I'm speaking about. And the trilogy also naturalizes somehow a global state of emergency. In the real world, several states are more and more states invoking national security clauses to justify restriction and exceptions on many international law obligations. One may think, for instance, as the United States has restricted the sale, invoking exceptions in WTO context, has invoked exceptions to restrict the sale of advanced chips and artificial intelligence tools just to China, because they said that such technologies could strengthen China's military and surveillance capabilities. And the case law, lastly, has clarified that such clauses are enforceable, are justifiable, that these state measures based on them can be challenged in the international law litigation, and also recognized some state discretion. In an institutional perspective, we may think to the international health regulations of the Health Organization, that is, and in the latest post-COVID discussions which aim to obligations, we may think to the pandemic agreement. No? Inspiration from the novel integrated and centralized management of resources, pragmatically, way of fact, de facto, translated to implement. Then we have the dark forest deterrence. The dark forest deterrence envisions a balance based on mutual exposure and annihilation between civilizations. In practice, we know that we have nothing of this in a legal perspective, but the narrative, to me at least, has reminded that deterrence without reliable communication channels increases, without reliable communication channels, increases the risk of escalation. What I'm speaking about, we all know that in the novel softens obscure human thought. So people doesn't know what there is no transmission of ideas, and this increases the risk of escalation and misperception. So we know that this suggests us to strengthen verifiable transparency, substantial reductions in arsenal, and management of technological risks. So again, in the novel there is an extraordinary use of force justified for the reason to guarantee the survival of humanity mostly. In reality, we know there is a doctrine of responsibility to protect, enshrined in 2005, I think, that imposes each state responsibility to protect its own populations, and whenever this, from genocide, war crimes, ethnic cleansing, and so on, and this doctrine calls for, as just words, timely and decisive collective action by the Security Council. Its application is very, very controversial. There is no unique approach to this. And what this suggests us strongly, we can think to expansion and strengthening of international organizations powers, but they must be accompanied by checks and balances, very, very robust, so to say. And I think by substantive and procedural both limits, independent review, sunset clauses. I too come from international economic law, so sunset clauses for me are very, very, very important. Then the trilogy prioritizes effectiveness, survival first is the idea, over democratic legitimacy. International practice looks like holding for the opposite. Legitimacy and consensus are prerequisites for action, often at the cost of slowness and stalemate. There is a passage in Yat-sen where a judge says says the presumption of innocence, I'm reading from the book, does not apply to crimes against humanity. This is a principle of international law, says the book. It's established at the start of the crisis era, so we here see how things have shaped international law in that context. There are a lot of passages like this. For instance, escapism is a crime against humanity in the Netherlands. And the crime of extinction of life on Earth has to be added to international law. There is another passage in that forest. So I think pop culture is not a mere reflection of law. I think it somehow shapes how rules and international law that sometimes seems very, very far from people. It's not this way. So how its rules are perceived, not only perceived. When we come to what's more science fiction, I think this offers a laboratory for imagining legal responses to unprecedented technological and existential challenges. Narratives remind us that law is not purely rational, but deeply human, influenced by imagination, emotion, and collective affairs, and states built on collective affairs. And while, sure, three bodies problem constitutionalized in the United Nations is fiction and it is used for narrative reasons, of course, I think it sparks also critical debate on legitimacy, on accountability, and global governance, international governance, better, in time of crisis, sorry. So I think that ultimately engaging Russell with pop culture is not optional. As a legal scholar, I think I feel somehow compelled to do this because it's essential to understand law, understand laws, international law's limits, international law's characters, and how international law can shape our future world. That is not so foreseeable, I think. I thank you all for your patience and
Thank you so much.
a lot of things, let's say.
Read so many quotes and
Hello, everyone. Thank you so much for this opportunity to speak about this incredible novel. When Lorenzo first invited me to think about it, and he said it's a science fiction, I was thinking, I haven't read science fiction in ages, it will be difficult. It was not difficult at all. It actually read very real. This is what I loved about it. So, just to explain where I'm coming from, I will touch upon the points raised previously, but from the perspective of art and international law to some extent. I study art, aesthetics, international justice, and I was trained as an international criminal lawyer. So this is my paradigm. And my presentation will touch upon the book itself, its metaphorical depths, and I will have a couple of examples how it's precisely relevant, legally relevant to international law. So just to build on what Professor Ruotolo was saying, and then perhaps to build more on the first presentation by Professor Lee and his references to transcending ego, I call it transcending self-interest, and more the philosophical dimension of the book. And I will speak about imaginal and imaginary and the role of imagination and how indeed it is legally relevant. I apologize in advance. It's an argument that I'm still developing, so some arguments may not be as sharp, but the article is coming forward. I have to read the name of the journal. It's an Oxford journal, and it's partially based on this book as well. It's called Global Community Yearbook of International Law and Jurisprudence. The article is called The Self-Reflexive International Law, and I will refer to some arguments from the article. So the book has deep metaphorical depths, and 2 points in which I felt it's very relevant to where we are now is the discussion on the use of force, indeed, and how to conceptualize, for instance, of the crime of aggression, if this aggression comes from outside of the terrestrial plane. And I will specify what I mean by that. I was commenting recently on a book, The Morality of the Laws of War, by Marcela Rodolfi Prieto. It's an excellent book in which Marcela suggests collapsing jus ad bellum and jus in bellum. What that means is that she says there is moral war, so-called just war, and there is unjust war. And in cases of unjust war, the combatants lose their right to kill others, whereas just combatants, they have the right to kill others. So we're collapsing morality and the substantive questions of jus in bello. So we're saying, yeah, you started the war, hence you can't really kill. So this is very interesting discussion because it's becoming more and more popular, but I think that the questions raised in the book, they make us think deeper about morality. Whose morality? What kind of morality? And what happens if there is this extraterrestrial invasion? Then they have their own reasons why they may be invading Earth. They may be refugees. So this relativism, moral relativism, is very important to think about when we talk about aggression, use of force, and then maybe more practical topic is the war on terror, which is legitimized and sometimes mixed with non-international armed conflict. Now we have the war on drugs, again, unlawful use of force, which is presented as lawful. And then perhaps the next phase, and I'm being imaginal here, the war on aliens. Some of you may think, why is she saying that? I don't know if you saw The Age of Disclosure. It's a very popular documentary. Now it's #1 on Amazon Prime. And it talks about certain discoveries by American military of objects we don't know where they come from. So the popular culture is conditioning us to thinking of the external threat coming from somewhere else. And then maybe something a bit more grounded is the 3R Atlas. I don't know if any of you know about it. It's a mysterious comet that exhibits certain patterns of behavior, and it's now in the current solar system. So we are now slowly entering the age where we are conditioned to think of something unidentifiable, extraterrestrial, as being part of our thinking. And it's positioned as in the Age of Disclosure, if you look at it. So these are the practical examples why it's relevant. And then, of course, climate refugees. When I was listening to the novel, I was thinking about the parallels that it draws between the questions of extraterrestrials, life that's seeking to be here on Earth, because they have problems there. They're not just aggressive, they actually have to find another planet to live. It's very similar to the questions of climate refugees and generally migration. So now to the imaginary and imaginal. So these are just practical aspects, but more about the compulsion of Western philosophical tradition to focus on the observable. And this is the core argument in this paper that I mentioned in the beginning, which advocates for the new model of international law, which is self-reflexive. The instrument that I suggest is imagination. And I refer to the work of Henri Corbin, for example, who is a French philosopher and Iranologist, who pointed to the Western bias towards everything objective and observable as being scientific at the expense of the subjective and internal, both individual and collective. And he says that oftentimes when we talk about imagination in the Western world, we talk about fantasy, which is not grounded in reality. And I think the book uses imagination in a very productive way because it's not ungrounded social fantasy. Also, art historian and philosopher John Dewey calls it flights of fancy, when children are fantasizing and it's not grounded, really it's not productive. So this is to be distinguished from the imaginal or imaginary in Corbin's understanding, more Eastern understanding of imaginary as being the archetypal imagination, which is deep intelligence. Corbin goes as far as to say it's actually between perceptual, which is sensory input, and cognitive, which is intellectual, but it has cognitive value. It's actually also John Dewey says the same. It has noetic or cognitive value, legally relevant, so to speak. So the instrument is there, the book is there as an instrument, and then I move to the 5 lessons that I offer on the basis of this imaginary intelligence of the book for the future of international law. And I explain how they fit within this paradigm of the self-reflexive international law. So the 2 lessons are more symptoms of the world that we live in right now. That is the need to look at technology and its unsettling effects on our collective ontology, especially to the extent that we are now grappling with the fact that human intelligence may not be the most intelligent intelligence out there, that technological intelligence, and we see it more and more, is slowly overpowering the ability of humans to control the environment. And in my article, I say that technology is no longer just predicting our choices, it's modulating them, which is a very different attitude. So our choices are shaped by technology, and then there is a reflexive loop. So this is also how we practice international law nowadays. It's no longer, I have an argument, I collect legal sources, and then I offer an argument to the legal community or the legislature. Practicing and researching becomes more of a looping exercise where I collect data, I test it, I build solidarity with some colleagues, positionality is not an option anymore. So it's becoming much more modulated. So this part on technology, the book also shows us the limitation of human-created technologies, the cell phones metaphor. And then the second symptomatic lesson is unknowns, basically dealing with uncertainty. And this is fascinating. It's very humbling reading this book because it shows us how much we don't know. Because again, especially in Western epistemic traditions, there is so much emphasis on what we know and what we observe, but then there is not enough emphasis on what we don't know. So with respect to uncertainty, I think it's very important for international lawyers to talk about uncertainty, and we have a lot of lively debates now, one on Agile Talk from just last month, conducted by Sarah Nolan, with great contributions by Professor Becker-Lorca. Also, we have Marko Milanovic and Ann Peters. They talk about authoritarian regimes versus democratic regimes. So they frame this uncertainty in a sense of this civilizational battles and the good guys need to win. So that's one way of framing it. I'm of course oversimplifying, but for example, Ann Peters has an article about monsters in international law. I guess all of us can guess who the monsters are. Again, that's one position. Then there is another group, Professor Philip Webb, Hilary Charlesworth. They talk about going away from the crisis paradigm and going towards a epochal paradigm where we think more long term. And then they suggest some creative tweaking of what we have to deal with uncertainty, but then it becomes really still linear in a way. So we don't escape our biases in that sense. And then there's a group of scholars who say, well, it's too complex. We actually can't use one epistemological tool for international, be it law or history. We need to acknowledge complexity and we need to stop trying to solve the problem because lawyers are conditioned all the time to solve. And I'm thinking about Rebecca Mignon-Mondavi, Dimitri van der Merche, but more and more scholars, especially the younger generation, also trained in interdisciplinarity. So this is the uncertainty and unknowns and the debates, and then where am I in this? And then with that I will also conclude. So what I'm developing is the self-reflexive paradigm of international law, which tries to balance this Western obsession with the objective and observable with more attention to my biases, where I come from, and collective subjective. So basically, the paradigm which brings the imaginal, but also tries to look more internally. So the other three lessons that I offer from the book, which I get from the book, is coordination. So here I would like to connect to Professor Lee's reference to transcending the limitation of the ego. I think Lorenzo already knows the win-win paradigm. We discussed it in the context of using aesthetics to transcend the deterrence paradigm, to try to think what it might look like to find a solution that works for everyone, and if it's possible at all. I got a recent review in Spanish, sorry for the deviation, but I just have to say it. Someone translated this win-win in Spanish and it sounded so beautiful, ganar, ganar. Right? Ganar, ganar. So the win-win paradigm, the common project, why the book offers this perspective? Well, precisely because it forces us to think outside of the state-centric paradigm. I'm Russian, we have Italians, Chinese here. What unites us? And also what unites us is the ability to perceive beauty. And that connects to my work on aesthetics. We are all able to perceive. And this universal ability to perceive allows us to transcend self-interest. There is a deeper layer of this argument, but I won't go there. The second lesson, which is more lesson, is taking different perspectives. So the ability to transcend individualist perspective. I refer to works of Jürgen Habermas on communicative theory. He talks about the importance of being the observer and participant at the same time in the discourse. And he offers these three elements of the truth or validity claim of an effective coordinated action. It sounds really much better in German. I still have a couple of minutes. I will say it in German. Yeah. So, Jürgen Habermas, how to make effective coordinated action. So, the precondition we mentioned, it needs to be from the observer and participant perspective simultaneously, and three elements: truth, which is Wahrheit, which is objective reality, what we mentioned before, something that I can observe. Then we have normative rightness, Richtigkeit, so social conditions, so our shared value space. And then we have truthfulness, Wahrhaftigkeit. Still, sounds really beautiful, and the truthfulness part is actually authenticity, sincerity. So sometimes one element is missing and then the whole project doesn't work out. So in my article, this one I mentioned, I used this paradigm, and then I used the paradigm of Ken Wilber, my new hero, American philosopher. He works on integral theory. So 4 ways of showing up to reality. It's really based on this Habermasian model. And with that, I'm going to conclude. So Ken Wilber, he points to the same objectivization bias of Western civilization, that we're focusing too much on law out there. So the law is there, I'm interpreting it, but I'm pretending like it's objective. And then also Western science really loves systems. So basically it's still objective, but how different elements work together. And then for Ken Wilber, there are also 2 other parts, which is individual subjective, which is studied through phenomenology. And that really made sense why I was so interested in art and aesthetics, because it's exactly this phenomenological perspective that was, in my view, missing before. Now we have more works on that. And then there is also subjective collective, which corresponds to social reality of Habermas, so being aware of the social space, of cultural space. So perspective taking happens within the whole paradigm, just in one of the quadrants. And then introspection, which was my last lesson from the book. So it's generally my interest right now. What would it look like to have a more introverted, more self-reflexive international law? And I think the book poses great questions to think deeper about that. Thank you.